Hello friends, welcome you all to Dnyanadeep Academy. Now in continuation to the topic on fundamental right, today we are going to study one of the most important fundamental right, which is Article 21. What is so important about Article 21? Here remember my dear friends, Article 21 is the most liberally interpreted article of Indian Constitution. It has been interpreted so many times and in so different ways that it is called as a colorless legislation. Why colorless legislation? You can put any color in it and that color will be mixed with that water. That's why it is called as a colorless legislation. Article 21 is basically about a protection given to everyone regarding life and personal liberty. So we'll try to understand this particular article in a very interesting manner. So first thing, Article 21 is about protection given to an individual's life and personal liberty. This is first important thing, Article 21. Now why this article is important, we'll try to understand. See, suppose this is a common human being, right? This is common human being. Now this human being has an inherent right of life and personal liberty. Life, right to live, personal liberty, liberty to do anything as he or she wishes within the limits of the constitution, liberty to express, liberty to talk, liberty to walk, liberty to have profession, liberty to do anything. So all these things are there for this particular individual and it is called as right to life and personal liberty. Then there are three important threats to this individual. Those three important threats, first one is private person. Now, private person can be anyone. It can be me individually, Mahesh Shinde. It can be a businessman. It can be a rickshaw puller. It can be a goon. It can be a terrorist. Anyone can be there. So, this person has a threat from this private person first. This person has a threat from executive. Who are executive? Executive stands for Prime Minister plus Council of Minister, Chief Minister plus Council of Minister, and the entire administrative machinery running under these executive are a threat to this individual. This is second threat. Third important threat is legislature. Right. Third important threat is legislature. That is Lok Sabha plus Rajya Sabha or Vidhan Sabha plus Vidhan Parishad or Legislative Council. So these are three important threats to the life and personal liberty of an individual. Now, if any private person makes an attempt to take away life and personal liberty of this individual, in that case, this private person will be booked under law and he or she will be put behind bar. It means this person has legal protection from any kind of encroachment by this private person on his or her life and personal liberty. It means this private person cannot take away life and personal liberty of this individual, as life and personal liberty of this individual has been protected legally. So this person has protection from private person, complete protection. It is given under various laws, constitution and everything. Now, what about executive and what about legislature? These two are very, very important institutions. And these two important institutions can take away life and personal liberty of this individual through various ways, through various methods and through various means. How it can be taken away? So, an executive can issue an order which is called as executive resolution or government resolution. You must have heard a very important word in your home, GR. GR aaya hai, barabar hai? So it is a kind of government resolution or government order or executive resolution or executive order. What if an order issued by Home Minister to beat people who are protesting? Right to protest, your right to liberty under Article 21. But you are being beaten by police on the order of Home Minister, then what about your fundamental right to liberty? Do you have protection from Home Minister who is part of executive? This we are going to study in Article 21. Or if Parliament makes a law that you people do not have right to move on this particular road. Parliament has made a law which is supreme law making authority. Then right to move on a road is your right to liberty. Then this right to liberty is violated. Then can you challenge this parliamentary law or state law in the court of law? So this is the question that will make an attempt to analyze whether this person's right to life and personal liberty is protected from legislature and executive or not, or can this legislature and executive take away right to life and personal liberty of an individual. This we will try to analyze in this particular article. Clear? Now, this is very important article. First, try to understand this point which I explained just in few minutes back. So, go through this video time and again so that you will get an idea. Now, we'll move forward towards article 21 and we'll try to understand what it says. See. So, first, article 21, it talks about protection of life and personal liberty. Now, what article 21 says? It says, no person shall be deprived of his life or personal liberty except according to procedure established by law. I will not go into the analysis of this line. I will just try to explain you what is this procedure established by law. First, law. What is law? These are set of rules, regulations and terms and conditions which are passed by a legislature. So, who makes a law? Law is made by, in case of India, it is made by Parliament in the center, and in case of state, it is State Legislative Assembly in the states. So, a procedure established under law, it means a procedure established by Parliament. So, this person have been provided with right to life and personal liberty, but there is an exception to this life and personal liberty. What is that exception? This life and personal liberty can be taken away by procedure established by law. It means this life and personal liberty can be taken away by a procedure established by Parliament. Where is the word Parliament? Here comes the word Parliament. Will come forward. So, this is just simple. I just wanted to tell you what is article 21. Article 21, it talks about right to life and personal liberty. And it says no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, fifth important factual things. Article 21 is applicable to both citizens as well as non-citizens. Means it is applicable to every human being irrespective whether that human being or that individual is citizen or not. Article 21 made an attempt to explain what we have in India, whether we have procedure established by law or we have due process of law. Now here, an important point. This procedure established by law has been taken from English Constitution, that is, it has been taken from UK. Due process of law has been taken from US Constitution, that is American Constitution. Then what is basic difference between these two things? See, procedure established by law, it makes Parliament supreme. Procedure established by law makes Parliament supreme. It means whatever Parliament says shall remain final, whereas due process of law, it talks about judicial supremacy. It means what judiciary says shall remain final. Clear? So this is basic difference, and here we will make an attempt about what we have in India, whether we have procedure established by law or we have due process of law. We will make an attempt to explain this important point, what we have, whether procedure established by law or we have due process of law. Clear? Before, I just want to give you a simple understanding about these two lines in your own language. See, I will try to explain these two words in a simple scenario. Let's say your friend has called you for the party. Party is there in the night at his home. You are going for the party. Now friend asks you that you come for the party at 9 a.m. and you tells that friend that, dear Rakesh, I will be there by 9:15. See, you are telling your friend that you will be there by 9:15. So it is fixed time. It is a procedure that you will reach at the party venue by 9:15. So it is a procedure. So it is procedure established by law. Now, what about due process of law? You know, the party is going to start at 9 o'clock. You are going to reach at 9:15, but real party starts at 11:30 and you have many works pending at your office or at your home. So it tells your friend, my dear friend Rakesh, I will be there in due time. See, you are using word due time. It means I will be there on rational time. I will be there on correct time. So we'll reach party at 11:30 instead of 9:30. So when we take word by word meaning of a particular law or a statute or what is being said in words, and we do not go into the intentions, I'm using word, we do not go into the intentions, it is procedure established by law. Whereas when we take rational decision, when we go into intentions of a particular thing, when you think about what are the intentions, what are the possible outcomes, what is rational, what is good, that is called as due process of law. That's why Article 21 makes an attempt to various judicial decisions that what we have in India, whether we have parliamentary supremacy or we have judicial supremacy, that will make an attempt to explain in this very simple article. Clear? Now see. So, first came Gopalan case in 1950. In Gopalan case, Article 21 was narrowly interpreted. This is important. Article 21 was narrowly interpreted. Now what it said? See, I will repeat the article once again. It says, no person shall be deprived of his life or personal liberty. It means every person has been provided with a fundamental right of life and personal liberty. No person shall be deprived of his life or personal liberty, except, it means there is an exception. There is an exception to the protection provided to that person's life and personal liberty. It means I am saying that yes, you have right to life and personal liberty. Yes, you have. But there is an exception to this protection. What is that protection? What is that exception? That exception except procedure established by law. It means what it says? It says you have right to life and personal liberty, but this right to life and personal liberty can be taken away by procedure established by law. It can be taken away by procedure established by law. It means a person's life or personal liberty can be taken away by law. Who makes a law? Legislature, that is parliament, and state legislature can make a law. It means going in the beginning, see, as per A.K. Gopalan case, if this is a person and this person has been provided with right to life and personal liberty, so who cannot take away right to life and personal liberty? This private individual cannot take away, this executive cannot take away, cannot violate right to life and personal liberty, but this legislature can violate as per Article 21. Why? It has been said this person has been provided with right to life and personal liberty, but there is an exception to right to life and personal liberty, and that exception is procedure established by law. That is a law made by legislature can violate this right to life and personal liberty. So move forward. So in A.K. Gopalan case, Article 21 was narrowly interpreted. So person's life or personal liberty can be taken away by law, that is legislature. It means person has protection from private person, as we have seen in the previous diagram, and has protection from arbitrary executive action, that is, but not from arbitrary legislative action. It means your right to life and personal liberty is not protected from legislative action. It means legislature can take away your right to life and personal liberty. It means legislature can take away life and personal liberty of an individual even by arbitrary action. And judiciary can check only procedural aspect. It do not go into intentional aspect. As per A.K. Gopalan case, judiciary can check only wordly aspect, or it can check only procedural aspect. It cannot check intentional aspect. Procedure established by law prominently reflect parliamentary sovereignty. So in A.K. Gopalan case, it was very clearly seen that we have parliamentary sovereignty, or what parliament says is final in India like in England. So this was the first judgment in case of Article 21. Then came Menaka Gandhi case of 1978. Now what it said? In Menaka Gandhi case of 1978, there was wider interpretation of Article 21. In Menaka Gandhi case of 1978, there was wider interpretation of Article 21. And what was there? Now, what judiciary said during Menaka Gandhi case? We'll try to understand. Judiciary said, no person shall be deprived of his or her life or personal liberty, same like Article 21, except procedure established by law. It said that yes, this sentence remains, except procedure established by law. but this procedure should be just, fair and rational. It means yes, it's true. Judiciary has the right, legislature has the right to take away life and personal liberty of an individual. Yes, we accept it, right? Legislature has the right to take away life and personal liberty of an individual. We accept it, but this law made by parliament should be what? It should be just, it should be fair, it should be rational. It means here only procedural aspect was seen, right? But here intentional aspect was seen. Intention, what is the intention is being seen here in this particular case. We are going to study what is the intention. Here only procedural aspect is being seen, but here we are going to study the intentional aspect. What is the intention? Why we want to go for this thing? So here we are going to study intentional aspect of this particular thing. So what Maneka Gandhi case says, no person shall be deprived of his life or personal liberty except procedure established by law, but this procedure should be just, it should be fair and it should be rational. It should be just, it should be fair and it should be rational. So this is the simple thing which they are expecting. Clear? So this was the simple Article 21's wider interpretation under Maneka Gandhi case. So it means due process of law. See, in first Gopalan case we had procedure established by law. In Maneka Gandhi case we have due process of law. Why? Because judiciary will go into the intentional aspect of law. Judiciary clearly said yes, parliament has the right to make law. And the right to make law is supreme. No can challenge that right to make law. But as a judiciary, as a organ, as a validating organ of constitution, we have the right to check validity of parliamentary law. We can check validity of parliamentary law. We can question whether this parliamentary law is just, fair or rational, and it means due process of law. It is a wider interpretation of Article 21. It means as per Maneka Gandhi case, a person has protection from arbitrary action of both legislative and executive. In Gopalan case, a person's life and personal liberty had protection from arbitrary action of executive only. But after Maneka Gandhi case, a person's right to life and personal liberty has protection from arbitrary action of legislature as well as executive. This signified we have synthesis of parliamentary sovereignty and judicial supremacy. How synthesis? We have studied this point while studying features of constitution, but here what it says, yes, a person's life and personal liberty can be taken away by legislature. So it shows parliamentary sovereignty, but this law made by legislature should be just, it should be fair and it should be rational. It shows we have judicial supremacy. It means in Indian constitution, we have synthesis of parliamentary sovereignty and judicial supremacy. Article 21 is so wider that it gives every individual right to live with human dignity, to make man's life meaningful, complete and worth living. That's why it is said Article 21 is the most widely interpreted article of the Indian Constitution. Supreme Court declared certain point as a fundamental rights under Article 21, and the list is not exhaustive. It is open for many interpretation. First one, right to live with human dignity, right to privacy, right to shelter, right to health, right to free legal aid, right to speedy trial, right to information, right to sleep, right to electricity, right to freedom from noise pollution, right to free trial, right to timely medical treatment in government hospitals. So this was the Article 21. It shows clearly that we have synthesis of both parliamentary sovereignty and judicial supremacy. So my dear friends, all these videos are available on our batch in the app. Keep sharing with your friends, and whatever questions you have regarding this point, please put in the comment box of YouTube channel. You'll definitely get the answer. Till then, thank you very much. Have a good day. Thank you.